Okay, good morning, folks. Thank you all for being here bright and early this morning. This morning we are having a drive-by, walk-through, flyover, whatever we want to call that, of S89, which is currently located in the House Judiciary Committee. It's a bill which we spoke briefly about that is in reference to forensic facility, establishing forensic facility capacity in the state. I want to be clear that we are only going to be reviewing those aspects of the bill that deal with people with intellectual and developmental disabilities. The mental health aspects of the bill are being reviewed next door in healthcare. And so the things that affect both populations, like the panel, for instance, we will look at those kinds of things. But if it starts to veer off into something that is not under our jurisdiction, just beware, I will veer us back into our jurisdiction. So with that, Katie is going to walk us through the sections that are under our jurisdiction. And thanks so much for being here. Bright and early, Katie. Appreciate it.
No problem. Good morning.
Good morning.
Katie McLean, Office of Legislative Counsel.
So you have a copy of this on your website.
So this, let me pull it up. The amendment we have, you'll see it sort of color coded, sort of like the color coding that you're familiar with seeing in your draft. So this is very much still a work in progress in the House Judiciary Committee, and those layers of colors are showing new edits versus old edits. So it sounds like you're fairly familiar with this bill already. But just to sort of step back and do kind of the big picture overview of what this is about. So this creates a new type of facility. It's a facility that is envisioned that individuals who are criminally justice involved with a particular type of charge or found not guilty by reason of insanity could potentially be committed to a forensic facility if certain criteria are met. This is not a hospital. It's not hospital level care, even though the language specifies that where the current thinking of where it would be located is one of the units in the Vermont Psychiatric Care Hospital that would have a new type of licensure for that unit, a therapeutic community residence, which is a license that Dale oversees. But it's not hospital level care. As I said, it would be overseen by two departments. It would be overseen by Dale and DMH. And the way the bill is structured, you see that we're making amendments to the mental health sections, which I will not go through with this committee. And then we'll skip ahead to language about how an individual could potentially be committed to a forensic facility if they have intellectual disability. This version sort of envisions that a person could come right from a correctional setting to the forensic facility, but it also envisions a person who's meeting all the criteria that we've discussed that's in the bill could also initially have another placement at another community placement, and there could be a continued order which would transfer them into the forensic facility. So they're not necessarily coming directly from a correctional facility. And then at the very end of the bill, there's some reporting language, and that is language about how is the programming going to work for these individuals and what is the staffing going to look like, because we have sort of two different populations. What is the oversight going to look like shared between two departments? So that is some language we can also look at. Okay, so as I already said, we have this purpose statement, which says that we have the purpose of the act is to enable the commissioners to seek treatment and programming for certain individuals in a forensic facility. An initial forensic facility shall be located in the 9-bed unit of the Vermont Psychiatric Care Hospital, and the unit shall be relicensed as a therapeutic community residence. I should say that the bill is drafted. Whenever we refer to the a forensic facility. We don't say, it doesn't say the forensic facility, it says a forensic facility. So the language is broad in that there could potentially be additional forensic facilities. This doesn't limit it to having one facility in the state, although that is what is being contemplated at the moment.
Excuse me, Katie. Would that also reference the fact that, it says, an initial forensic facility be located there? Does that, well, I'll ask the department of that. So that's a reminder, I guess, to only seek clarification on the words that are on the page from Katie, but the policy we'll talk with the department about. Okay, thank you, sorry. Stop myself.
So this first section creates a human services community safety panel. Maybe I should even take a step back from here and say that the version that you received from the Senate had a rulemaking section that House Judiciary is contemplating removing. And that rulemaking section asks the departments to do rulemaking about how what the admissions criteria would be and what the process would be for coming into the facility. And so this version that House Judiciary is working on removes the rulemaking section and instead tries to embed within the statutes what that admission criteria looks like and what the process would look like. So this language in the Human Services Community Safety Panel did not come over from the Senate. This is language about process that has been added by House Judiciary. So there's hereby created the Human Services Community Safety Panel within AHS. The panel shall be designated as an entity responsible for assessing the potential placement of individuals at a forensic facility, pursuant to the next section we'll look at, for individuals who present a significant risk of danger if not held in a secure setting and are charged with a crime for which bail is not available, or were charged with a crime for which bail is not available and adjudicated not guilty by reason of insanity. And then we have members of the panel.
Sorry, there's a question.
Can I ask just a broad question? I don't think of the word forensic being used with facility. Can you kind of give a definition on how that works? Yeah.
So the individuals, we'll look at the definition of forensic facility, but the populations of persons who could end up in the forensic facility are individuals who have a criminal charge against them. They're found either not competent or to stand trial, or their case has been adjudicated and they were found not guilty by reason of insanity. I should flag, because I know this isn't the Judiciary Committee, that if you're not competent, that's sort of a point in time assessment. So somebody at one point in time who is deemed not competent to stand trial could potentially, under this language, spend time in the forensic facility and regain competency and be tried at a later date. These are individuals who have a certain level of crime. We know that because it's crime for which bail is not available, so a significant crime. And we're also looking at individuals who have a degree of a higher degree of risk of danger to themselves or others that makes them candidates. I'm not sure if I've answered your question, but it's this concept of certain populations that are coming through what I think of as the criminal door to get into the system and to get treatment.
Forensics is like investigation or something, or where they're looking at a crime scene. So it just seemed like a interesting word to use there. Okay. Thank you.
Katie, does this bill contemplate that anybody who is placed in this, not anybody, individuals with intellectual or developmental disabilities who are placed in this facility, that they would have to be committed to the custody of the commissioner?
Yes.
So that's, I'm not, would that be an appropriate thing for you to explain to committee members that committed to the custody of the commissioner? I'm not sure that everybody has a familiarity with that.
Yes. Why can I save that? And yeah, I'll do the panel piece and the definition of the facility, and then we'll jump ahead to the procedures, and that sort of talks
Covers
about
it.
custody, yeah.
Okay, Noah and then Jessica.
Real quick, thank you, Jerry. Just to Dan's question. The people who are served are called forensic clients, and that's the legal definition. I had this conversation with Mark. That's why it's called a forensic facility.
When you get to procedures, would we learn more about how a correctional facility versus, how a forensic facility is different as far as like being locked in, being, like some of those sort of
I think the department was.
Yeah, I don't think, the words on the page are, it has to be secure. So we're looking at physically secure building.
just like a
Lots,
correction.
but besides like the programming and how it's different from a correctional setting, I think you'll have to get that from the departments. So members of the panel,
Yes. Excuse me. Oh my gosh.
so the membership of the panel, we have the Secretary of Human Services, Commissioner of Mental Health, Commissioner of Jail, Commissioner of Corrections. We have language that the panel shall have the assistance, technical, legal, fiscal, and administrative of AHS and the 2 departments, or 3 departments.
Representative Donahue.
So when we list people like that, I know we've done it differently in the past. Sometimes the language, it's implicit that you can have their designee, and sometimes we say or designee
Yeah.
versus we intend only that person.
This only allows for that person.
It's only,
Yeah, it could be changed, but right now this is how it reads, yeah. Okay, so then we have language in Title 13 of the Vermont statutes annotated. Title 13 are the criminal justice statutes. So we have language that the person who is the subject of the proceeding, the person's attorney, legal guardian, if any, the Commissioner of Mental Health or Dale, state's attorney or other prosecuting officer representing the state in the case should be given notice of a time and place of a hearing, procedures for hearings for persons with mental illness are covered under 18 VSA Chapter 188 and procedures for persons with intellectual disability at Chapter 206. So that's all existing law. Then we have new language. Once a report concerning competency or sanity is completed or disclosed to the opposing party in a criminal case, the Human Services Community Services Safety Panel that we just looked at may conduct a review on its own initiative regarding whether the placement of a person who is the subject of the report is appropriate at the forensic facility. So the panel itself could just say we need to review this individual's case and see if forensic facility is the appropriate placement. The review shall inform either the Commissioner of Mental Health or the Commissioner of Dale's decision whether to seek placement of the person in the forensic facility. But then, in subdivision 2, if the panel does not initiate its own review, a party to the hearing may file a written motion to the court requesting that the panel conduct a review within 7 days after receiving a report or within 7 days of being adjudicated not guilty by reason of insanity. So if the panel itself doesn't decide to do this review, a party to the criminal case could ask the court to make the panel do this review to see if the forensic placement is appropriate. And then in subdivision B, a motion filed pursuant to this subdivision shall specify that the person who is the subject of the proceedings is charged with a crime for which there is no right to bail and may include a person adjudicated not guilty by reason of insanity, and that the person presents a significant risk of danger to themselves or the public if not held in a secure setting.
so I'm assuming it's not in the language at some point. Did you get like a side list or reference to what those crimes are that no bail is permitted?
Yes.
Can I ask a question about the panel? And I want to make sure that I'm understanding how the construct of this is designed. Looking at an earlier version, I think B1 on page 3. So the Human Services Community Safety Panel, which consists of the Secretary, Commissioner of Mental Health, Dale, and Corrections, is reviewing the case, the situation, and that review shall inform their own decision. So they're giving themselves a recommendation.
Yes.
Okay, I want to make sure I was understanding it correctly. Thank you.
Thank you. Sorry, a party to a hearing under this chapter, who would be a party? Is that just the attorney or family?
Yes,
or-
we have a list in subsection A. Person subject to proceedings, person's attorney, legal guardian, if any. The commissioners could be a party or other prosecuting officer representing the state in the case. Yeah. Okay. So then subdivision C, page 4, the court shall rule on the motion filed, that's the motion whether or not the panel should have to do the review. Within 5 days, the panel review ordered pursuant to the subdivision shall be completed and submitted to the court at least 3 days prior to the hearing on section 4820. And then we have subsection C on line 8. And this is what is the panel doing when it's doing a review. So in conducting the review as to whether to seek placement of a person in a forensic facility, the panel shall consider the following. Clinical factors, including that the person is served in the least restrictive setting necessary to meet the needs of the person, and the person's treatment and programming needs dictate that the treatment or programming be provided at an intensive residential level. And dangerousness factors, including whether the person has inflicted or attempted to inflict serious bodily injury to another, attempted suicide or serious self-injury, or committed an act that would constitute sexual or lewd and lascivious conduct with a child, and there is reasonable probability that the conduct will be repeated if admission to a forensic facility is not ordered. B, whether the person has threatened to inflict serious bodily injury to the person or others if there is reasonable probability that the conduct will occur if admission to a forensic facility is not ordered. And then whether the results of any applicable evidence-based violence risk assessment tool indicates that the person's behavior is deemed a significant risk to others.
Okay, go ahead, question.
Does the panel have to meet any particular standard for their, like, clear and convincing, or
No,
like,
I mean,
there's no standard?
The court, when making an order, has a standard to meet.
Okay.
But the panel is guided by this language. D, the position of the parties to the criminal case as well as that of the victim. And then any other factors that the panel determines relevant in an assessment of risk. So those are sort of that's what we have for guidance for what the panel is going to be looking at. Okay. Next, we have a definition of forensic facility. This is in the mental health part, but it's cross-referenced throughout. So I thought I was going to sneeze, but I don't think I'm going to. So we should look at this. Thank you. Forensic facility means a residential facility licensed as a therapeutic community residence for which an individual initially committed pursuant to the first section, so 13 VSA 4822, a person who is in need of treatment or further treatment. That's reference to individuals who need treatment under the mental health system, and specific to individuals with intellectual disabilities. Page 6, line 1, 2, 13 VSA 4823, who's in need of custody, care, and rehabilitation pursuant to Chapter 206 of this title within a secure setting for an extended period of time. So that phrase, in need of care, custody, and rehabilitation, that's a term of art that's defined when we get to the intellectual disability statutes. And that is sort of a standard or criteria that the court and the commissioner is looking at when applying and determining whether a person should be committed to the custody of the commissioner of Dale. And we have language that a forensic facility shall not be used for any purpose other than the purposes permitted in this part or chapter 206, meaning that, the Dale chapter. And as used in this subdivision, secure has the same meaning as in 7620 of this title. So I'll bring you to 7620, even though it's in the mental health section, so you have that cross-reference as to what secure means. Okay, so 7620 is section 8, if you're following along. And so secure, if you're looking at subsection E, we have definitions. So the definition of secure was originally adopted when the General Assembly adopted or created the Secure Residential Recovery Facility. And we're cross-referencing it here, so secure has the same meaning with regard to both facilities. When describing a residential facility means that the residents can be physically prevented from leaving the facility by means of locking devices or other mechanical or physical mechanisms. So this isn't staff secure, this is that the physical facility is secure. Okay, I'm gonna scroll through this mental health language. Here we go. So what page am I on? I'm on page 19 of the bill, and then we enter a part of the bill for persons in need of custody care habilitation or continued custody care and habilitation. And this concept of continued custody care and habilitation very much mirrors what happens in the mental health context, that somebody could be under an initial order and then the department could apply if they deem that that person needs continued treatment, they'd be under an order of continued treatment. And so now the language here sort of mirrors the fact that there could be an initial order and a continuation of that order. So first we have section 12. Again, this is in Title 13, our criminal justice title. And this first language says that if the court finds that a person is a person in need of custody care and habilitation, a definition we'll look at in a bit, the court shall issue an order of commitment directed to Dale. So a person can be in the custody of Dale. That could mean lots of different things, and the department will tell you what custody looks like. It could be that the person is in some type of community placement setting. It could be more generally that somebody has sort of specific parameters, and Dale is sort of overseeing what those guidelines are with regard to a particular individual. But I have a feeling that the department can sort of offer you a better picture of what commitment looks like. So commitment to Dale for placement in a designated program in the least restrictive environment consistent with the person's need for custody care and habilitation for an indefinite or limited period of time. So commitment could be indefinite and commitment could be for a limited period of time. And that, it looks like it's new language, but if you look online too, we're just sort of reorganizing this language about designated programs in definite or limited period. Subsection B, when the commissioner seeks to have a person committed to a forensic facility. So there could be, Dale could make a commitment, the court could make a commitment to the commissioner of Dale that has nothing to do with the forensic facility and that sort of existing law. So this adds new law that if the commissioner seeks to have the person placed at the forensic facility, the commissioner shall provide a statement expressly stating that such a placement is being sought and setting forth the commissioner's reasons or the commissioner's determination that the clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendation of the panel that we looked at earlier. Placement at a forensic facility pursuant to this section shall constitute the designated program required by subsection A and required pursuant to 8845, which we'll look at in a bit. And nothing in this section shall be construed as prohibiting the panel from recommending additional services and habilitation at a designated program for a person committed under this section.
Yeah.
What happens right now since we don't have a
No, that's not-
That's policy?
That's, yes, we'll talk about that with the.
So yes, I can't answer the specifics what happens now, but there is a mechanism in place now, absent the forensic facility, where people could still be committed, but it would be Dale to tell, to talk about what those placements look like.
The term designated program here is that inclusive of, it had a different meaning previously. Is that now inclusive of the forensic facility?
Read it that way. Hold on. Placement
You're
of
about to use that
designated.
language.
Well, it's in, so we add it in A for placement in a designated program. And then, yeah, placement in a forensic facility shall constitute the designated program. So yes.
Section 13.
Do you see line six?
I'm sorry, I went back and forth between a written copy and which is a previous version. I'm sorry, what line is that on?
16. Starts on 15, placement at a forensic facility pursuant to this section.
Okay, thank you.
Mhm.
Subconstitute the designated program or a designated program? It says the, but there are other designated programs.
Shall constitute. It probably should be A. Shall constitute a designated program required by subsection A, because there are multiple ones, you're right. Okay, so subsection C, judicial review procedures for an order issued pursuant to subsection A of this section or discharge from an order of commitment shall occur in accordance with 8845, which we'll look at. So this doesn't apply to just forensic facility discharge. This applies to all discharge. And then we're cross-referencing the definition of forensic facility. So next, we're moving back to Title 18. There is a specific chapter on individuals with intellectual disability. So we're moving back to that section in section 13. We're adding a definition of commissioner. There's a definition of designated program here that is not being amended. It means a program designated by the commissioner is adequate to provide in an individual manner appropriate custody, care, and habilitation to persons with intellectual disability receiving services under this subchapter. We're adding a cross-reference to forensic facility, same definition. And then there are amendments to the definition of a person in need of custody, care, and habilitation. So this means a person with an intellectual disability, which means significantly sub-average intellectual functioning existing concurrently with deficits in adaptive behavior that were manifest before 18 years of age, who has inflicted or attempted to inflict serious bodily injury to another, or who has committed an act that would constitute a sexual assault or lewd and lascivious conduct with a child, and for whom appropriate custody, care, and habilitation can be provided by the commissioner at a designated program. And then we're adding a definition of continued custody, care, and habilitation. A person in need of continued custody, care, and habilitation means a person who was previously found to be a person in need of custody, care, and habilitation who poses a danger of harm to others and for whom the commissioner has, in the commissioner's discretion, consented to or approved the continuation of the designated program. A danger of harm to others shall be shown by establishing that in the time since the last order of commitment was issued, the person has inflicted or attempted to inflict physical or sexual harm to another. B, by the person's threats or actions has placed another person in reasonable fear of physical or sexual harm, or has exhibited behavior demonstrating that absent treatment or programming provided by the commissioner, there is a reasonable likelihood that the person would inflict or attempt to inflict physical or sexual harm to another. And then we have a cross-reference to the definition of victim.
Can I ask a question?
Yes, go ahead.
I'm just noting a difference here. So on page 23, it talks about threats or actions has placed another person in reasonable fear of physical or sexual harm. And then on page 22, and I saw it earlier in the bill as well, it focuses on constituting sexual assault or lewd and lascivious conduct with a child. I was just wondering why that was specified out with a child versus just general.
General, there hasn't really been any conversation on that, so that's
Okay.
the first time that question has come up. Okay. So section 14, you'll notice there are several sections, 14, 15, 16, 17, where we're striking out the existing law. I have my notes in front of me here. So I hope I say this accurately. There are subchapters 1 and 2 of this chapter 206 were repealed in 1995. And the remaining language, and this is subchapter 3, was left intact. But my understanding from the department is that without the language that was struck in 1995, this no longer is effective language. So the proposal is to remove the language, but because without the other language, the 1995 language, this is, to use the terms of the department, form without substance. So these 4 sections are being struck for that reason. Okay. Section 18. No determination that a person is in need of custody care and rehabilitation or in need of continued custody care and rehabilitation. And no order authorizing commitment shall lead to a presumption of legal incompetence. And then we get to where all of these sort of proceedings are in place as to how a person would be committed and what the discharge process would look like. This is all in 8845. So this section does a lot. It almost does the work of what 5 or 6 sections in the mental health statutes do, all in one section here. So first, also, I've put these headings in throughout to try to parse out what each of these sections are about, because I feel like it starts to get really confusing what we're talking about. And right off the bat, we're talking about how is somebody discharged from custody. And in subdivisions 1 and 2, we see that there are 2 types of discharge. So a superior judge after a judicial review could do a discharge, or there could be an administrative discharge from the commissioner. And you'll see as we go through that we've sort of broken out some of the language that follows as judicial review or as administrative discharge. So first, all of subsection B is about judicial review. First, we have language about commitment. So there would be a judicial review for commitment. Subdivision B1 is commitment. Subdivision B2 is continued commitment. So we have language that a person who's committed under Title 13, so they're coming through the criminal door, or this subchapter, shall be entitled to a judicial review of the person's need for commitment annually. The Family Division of the Superior Court shall have exclusive jurisdiction over all judicial review proceedings brought under this section. If no judicial review is requested by the person within 1 year from the date of the last order of commitment, it shall be initiated by the commissioner.
Yeah, question, Ann.
In terms of the language, right, where it says commitment, the wording seems to say if they're committed under this, they're entitled to an annual review. Doesn't say anything about the standards of the commitment itself, the initial commitment, before it gets to an annual review. Is that another section that talks about the judge's initial commitment?
No. I'm reading down below. No, we don't have anything about the initial commitment in this section.
Okay, so, or in the bill itself, or,
No.
okay. So we don't know what the standards are for a judge doing the commitment to the secure residence at all?
We have the language in 13 Title 13. Let me go back. So we have this language.
Can I ask a question? Because it's a follow-up to Ann. So in the current version, it seems like there was a section that was struck out that in Title 13, I don't know if it was an addition or the one that said prior to issuing an order of commitment to a facility, the court shall find the person is either presently incompetent, to stand trial, or has been found not guilty by reason of insanity.
Where are you?
I'm back on page 19 under section 12.
Okay. Are you in subsection A or B?
A.
Thank you. Offense of the person in custody, facilitation of the court shall order. So that is the commitment. And the court shall issue an order of commitment directed by Dale for placement if it makes a finding.
So, related to Ann's question is, on the draft number 2. I'm trying to figure out if this section has been struck that was in green on draft 2.3, the one that I just read, or is it in there someplace embedded and it's just been moved around? That essentially says that the court finds that the person is committed because they're incompetent to stand trial or has been found not guilty by reason of insanity, and that the evidence that the person committed the alleged crime is great.
That has been reorganized, and I can't remember from draft to draft. I'll have to go through this,
Okay.
this draft with
I just,
Because that's the initial
that's the
commitment,
initial-
that's what I'm looking for,
that
right?
language has been removed about, is great, the evidence is great, has been removed from this draft.
Okay, thank you.
You're welcome.
I guess I'm picking up on what you're saying, is that
There's no initial commitment,
the commitment.
and how that happens.
Yeah.
Right.
Yeah, so like I said, we have this,
Line.
right, we have this language in 12, in section 12, in the criminal language, that if the court finds that a person is needed custody, the court shall issue a commitment. But then in Title 18, you're looking for like parallel language.
But just, yeah, what are the standards, parallel to what
Yeah,
Chair just
Yes,
referenced?
I mean, what was theirs was the existing law that was taken out, I think.
okay.
So,
Let me take a look at this section has been reorganized so many times that I honestly can't remember where it may have
all
landed.
right, thank you.
Okay. So commitment, let's see, a person committed under our criminal title or this subchapter shall be entitled to a judicial review of the person's need for commitment annually. The family division of the Superior Court shall have exclusive jurisdiction. If no judicial review is requested by the person within 1 year from the date of the last order of commitment, it shall be initiated by the commissioner. However, a person may initiate a judicial review under this subsection beginning 90 days after initial commitment, but before the end of the first year of commitment, or if commitment has been continued under this subchapter, the person may petition for review after 90 days from the date of the order of continued commitment. So I take your point. We're only looking at review of commitment and not commitment. E2 is continued commitment. Language, if at the completion of the hearing, in consideration of the record, the court finds by clear and convincing evidence at the time of the hearing that the person is still in need of continued custody, care, and rehabilitation, commitment shall continue in a designated program, at least in the least restrictive environment consistent with the person's needs for an indefinite or limited period. If the court finds at the time of the hearing that the person is no longer in need of continued custody, care, and rehabilitation, it shall discharge the person from the custody of the commissioner. An order of discharge may be conditional or absolute and have immediate or delayed effect. So that's more of like the commitment order for continued commitment. Maybe this is a question for the department in their vision. Is it the vision that somebody is only initially committed through Title 13, in which case we have commitment language, and then the continued commitment happens under this title, which is why it's organized this way. So that is a conversation to have. I would like to be included. Yeah. But I think that is getting more clarity on the vision if if the initial commitment is just coming through Title 13, which is why we don't have that language here anymore. So I need clarity on that too. Subdivision B. In determining whether a person is in need of continued custody care and rehabilitation, the court shall consider the degree to which the person has engaged in or complied with the treatment and supervision provided by the commissioner. And then, so all of that language was not specific to the forensic facility. So you'll see this whole section kind of jumps back and forth. Are we talking generally about commitment to the commissioner of jail? Or are we talking specifically about going into a forensic facility? So this subdivision C, when the commissioner seeks an order of continued custody in a forensic facility, the commissioner shall provide a statement expressly stating that such a placement is being sought and setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, including the recommendations of the panel. Placement at a forensic facility pursuant to this section shall constitute a designated program. And the same question you asked, should this say a designated program? Nothing in this section shall be construed as prohibiting the panel from recommending additional services and rehabilitation. And we have language about attendance at the hearing, rules of evidence. Again, this zooms back out. So we're talking about all commitment. The commissioner or the commissioner's designee shall attend the commitment or continued commitment hearing and be available to testify. All persons to whom notice is given may attend the commitment or continued commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. The Vermont Rules of Evidence and Procedure applicable in civil cases shall apply to all judicial review proceedings brought under this subchapter. Notice of discharge. Notice of judicial discharge shall be provided to the prosecuting office, which shall provide notice to the victim unless the victim has opted not to receive notice. And then we move out of judicial review, or we move to a new subsection. So the subsection B was specific to judicial review, and now we're moving to subsection C, which is discharge from a forensic facility by judicial review. So this is sort of a specific category of judicial review for a forensic facility. The state's attorney or the attorney general's office and the victim are entitled to appear and provide their opinion as to whether the person should be discharged from a forensic facility. The prosecutor may call witnesses and present evidence. And then we have language about administrative discharge. So we're leaving judicial discharge, decision made by a court, and we're looking at a discharge decision that's made by the commissioner. So again, this initial subdivision 1 is broad to all custody, not forensic facility. At least 10 days prior to the effective date of any administrative order for discharge by the commissioner shall give notice of the discharge to the committing court and to either the state's attorney of the county where the prosecution originated or to the office of the attorney general if the office prosecuted the case. When the state's attorney or attorney general receives notification, the respective office shall provide notice of the action to the victim of the offense for which the person has been charged, unless the victim has opted not to receive notice. And then in subdivision D2, the language becomes specific to individuals being discharged from the forensic facility. So if the commissioner issues a notice of discharge from the forensic facility, the state's attorney of the county where the prosecution originated, or the office of the attorney general, if that office prosecuted the case, or the victim, or any combination thereof, may request a hearing on the discharge from the forensic facility to be held by the committing court within 10 days of receiving the notice under subdivision 1. The pending discharge from the facility shall be stayed during the 10-day notice period. And then on page 29, the state's attorney or the attorney general's office and the victim are entitled to appear and provide their opinion as to whether the person should be discharged from a forensic facility. The prosecutor may call witnesses and present evidence. And then we have language about discharge from a forensic facility generally. So regardless of whether it's judicial or administrative, The criminal division of the Superior Court shall retain jurisdiction over the person's underlying charge, and any orders holding the person without bail or concerning bail and conditions of release shall remain in place. Those orders shall be placed on hold while the person is held at a forensic facility, and when a person is discharged from a forensic facility to a correctional facility, the custody of the Commissioner of Dale shall cease upon the person entering the forensic facility. So this is saying that even though the person is going to a forensic facility, the charges still exist, assuming they weren't adjudicated not guilty, and that when the person is in the forensic facility, they're in the custody of the Commissioner of Dale, and if they return to a correctional setting, for example, if it's determined that they're now competent to stand trial, then custody will shift to the Commissioner of Corrections.
Thank you. I'm just, I'm not sure if this is so it says when a person is discharged from the forensic facility to a correctional facility. Like, why isn't that if? I mean, it's making a presumption that a person.
We need flow chart.
It is kind of needing a flow chart.
It could be an if. I think it's meant to capture the circumstance in which this occurs. So, if
I see what you're saying.
Yeah. A certificate of need. Do you want to hear about that, or is that healthcare?
We don't need to hear about it.
Okay. So this rulemaking section is all struck through. This is what I was referencing earlier, the language that came from the Senate where admissions criteria was to be, and process was to be created by rulemaking. Yeah. And then we have rulemaking language here that directs conforming changes with the changes in this act. So it would direct Dale to amend its existing rule on therapeutic community residences for the purpose of allowing the use of emergency and voluntary procedures, meaning restraint and seclusion, and the administration of involuntary medication at a forensic facility. So involuntary medication is for the population of persons under the custody of the Commissioner of Mental Health. But right now, therapeutic community residences don't allow for the use of involuntary medication. And because Dale regulates therapeutic community residents, they would be responsible for making the rule change to allow for involuntary medication.
So, is this, I heard what you just said. Is this part of there are existing rules around this, so it's asking people to make conforming changes. So what I'm trying to discern is whether or not this potentially could apply, involuntary medication potentially could apply to an individuals with intellectual disabilities.
There's only a judicial process in place in the mental health statute to create an avenue for involuntary medication. There's not language in the Dale chapter that allows for involuntary medication. There's no judicial process for that to happen for a person with intellectual disability.
So there's no judicial process. I'm just trying to figure out if these regulations impact that. The ability to do that.
That would be news to me. I would think that you would need statutory language to authorize a judicial process to see that. I have not heard that Dale is proposing to allow for involuntary medication by rule.
So I have a parallel question about the paragraph before. Persons currently in the custody of the Commissioner of Dale, are there any settings currently where emergency involuntary procedures are permitted to be used?
That's a better question for Dale. I'm not sure. I mean,
But this doesn't, does it, well, this would create that.
This would
Just
create
clarify.
that, yes.
That's what I was trying to get at.
Yeah. So this would create, not for
involuntary medication.
not for non-emergency, but for emergency it
Yes.
would.
So we have emergency involuntary procedures. We have seclusion and restraint could be physical restraint or medical restraint, so medication in emergency situations. Whereas involuntary medication, when we use that phrase, we're looking at non-emergency court-ordered medication for individuals in the custody of the Commissioner of Mental Health. I have a chart that shows the difference between those two, so I can dig that out if you want to sort of know the differences between the two.
Yes.
Yeah, okay.
Thank you.
Let me write a note to myself. I have an EIP chart.
When I start seeing TCR regulations and involuntary medication, and I know, I think the intent, we'll hear from the department, but is to have a sort of special TCR, not just TCRs in general. But, okay.
Yeah. Were the policy decision to be to allow involuntary medication on individuals in the custody of Dale, there would have to, I would argue there would have to be a process and statute that parallels what is in statute for mental health. And that this language, because Dale operates therapeutic community residences, and now this forensic facility would be licensed as a therapeutic community residence that would treat individuals with mental illness who potentially could receive involuntary medication. That's why Dale is the entity that is amending rules to allow involuntary
You're
medication.
talking about non-emergency involuntary medication.
Yes. Yes.
Thank you.
Okay, and the other rule change would be a change that DMH would be doing to allow for the administration of involuntary medication at a forensic facility, because right now involuntary medication is only allowed in the hospital setting. Okay. Language added by Senate Health and Welfare. We have a presentation. So by February of this coming year, DMH and Dale are required to jointly present the following information to the policy committees. A plan for staffing and programming at the forensic facility, including whether any specialized training will be required for staff members and whether any services provided at the forensic facility will be contracted to third parties. A plan for the joint management of the forensic facility by the departments and whether any additional resources are needed for the operation of the forensic facility. This is just technical, but we should have healthcare getting this. And then we have a report, which same thing, we need to have healthcare on this list. Annually by January 15th, for the years between 2025 and 2030, the departments of mental health and of Dale shall jointly submit a report to the policy committees containing the average daily census at a forensic facility, including trends over time, the number of individuals waitlisted for the forensic facility, and where these individuals receive treatment or programming while waiting for a bed at the forensic facility. The aggregated demographic data about individuals served at the forensic facility and the amount of an account of the number and types of emergency and voluntary procedures used at the forensic facility. And then our effective dates have changed. So we have rulemaking happening on passage, but otherwise this takes effect a year out.
And
Maybe this is more a comment than a question, but this does not require reporting on how many of those individuals in the forensic facility are under the custody of Dale versus DMH.
Correct.
okay, are there any further questions on the words that are on the page? All right, thank you, Katie.
Welcome.
Just also trying to figure out schedule. Thank you. We'll have to talk about that later.
Okay.
Because Judiciary Committee wants our comments on this.
Let me pull up my,
maybe if you could let Lori know what times you might possibly,
Okay, I'll go huddle with her now and
yeah.
talk to her about times.
All right, that'd be great. Committee members, we have, two witnesses who have not joined the Zoom room yet. But I know that they are on a specific time frame because they are, participating and, running, different events at the annual Voices and Choices Conference for individuals with, developmental disabilities in Burlington. And so, Max Barrows and Kirsten Murphy, are hopefully going to be joining us at 9. And we have Barb Prine from the Disability Law Project on as well. Barb, I want to check in with you. I'm just wondering if we should just sort of hold off for the next 4 minutes to see if they come. What is your time schedule?
Oh, she's not connected to audio yet.
Oh, can you hear us?
Here we go. Now she can.
Can you hear us? Barb, are you there, Barb?
Yeah,
Okay. I was just checking. I see Kirsten is joining, and hopefully Max will be joining shortly. Are you okay to? Do you have some flexibility in your time? In other words, to go third instead of first?
Are you asking me?
Yes.
I'm happy to be last.
Okay. All right. That would be great. And Kirsten's here. Kirsten, did you submit any written testimony? Kirsten, can you hear me?
Are you asking me?
Yes, Kirsten. Can you? Did you submit any written testimony? Can you hear us, Kirsten?
One moment, I have to fix my technology. I do not have any written testimony now.
Okay, all right. Pardon me?
She submitted something for fax.
Oh, okay.
But I'm prepared to testify.
Okay, all right. So we're going to start off with you, and hopefully Max is going to be joining us shortly. And so the floor is yours. You've been here before, so I don't think we have a room full of people here, as you can imagine. So thank you for being here this morning, especially knowing that you're double booked.
Yes, thank you so much, Representative Wood. So for the record, I'm Kirsten Murphy. I'm the Executive Director of the Vermont Developmental Disabilities Council. I've explained the function of the council to this committee in the past. It is a public board created by federal law in order to improve the lives of people with intellectual and developmental disabilities and ensure, very importantly, that individuals with IDD and their families have a seat at the policy-making table when policies like S89 that would impact their lives are discussed in Vermont. I do like to make sure that I disclose that I am a state employee, but I have special permissions to speak on behalf of the council in a way that other state employees do not. Of course, I am not speaking in any way on behalf of the Agency of Human Services, just on behalf of our public board. So the council members and staff do have grave concerns about the potential impact of S89 on individuals with intellectual and developmental disabilities who are served under Act 248 and found to be not able to stand trial and remanded to the custody of the Commissioner of Dale. Here are basically our concerns. I first want to say that this bill did kind of slip past us in the Senate. It didn't come to the State Program Standing Committee as it typically would have until after it had cleared the Senate. This particular gap in service, at least what Dale has identified as a gap in service, is not described in our system of care plan. So we were caught a little by surprise that this became an initiative that the Agency of Human Services seems quite invested in. When the council spoke at the Senate, we had not had an opportunity to meet with our members, and so we raised issues about the bill, but did not take a position. We have since met with our members who are self-advocates and family members, and they are strongly oppose the creation of a forensic facility that would touch individuals with intellectual and developmental disabilities. And here is why. The policy analyst at the council, Susan Aronoff, she calls herself a recovering attorney, is forever telling me that bad facts make bad law. You have heard that there are a small number of individuals that Dale does not feel can be safely served in the community. We disagree. Since the closing of the Brandon Training School for 30 years, Dale has served individuals, some of whom have significant public safety issues, successfully in the community. And it does not seem logical to us that the situation is somehow different right now than it has been for the last 30 years. It is the case that the system of care that supports people with IDD is extraordinarily stressed right now by the workforce and other crisis and other issues that you've been hearing about in your committee. But that should not be a reason to layer on a new institution-like setting to a system that has for 30 years been dedicated to serving people in the community. A different solution to the problem that Dale has identified really needs to be found, and that needs to be a community-based solution with adequate resources, ingenuity. If not our current agencies, then a private vendor. There are people that can do this work and can serve people safely and effectively in the community. Our concern about creating the opportunity to put people served under Act 248 in an institution-like setting is that it sets a precedent, and it's kind of the if they build it, it will, they will come kind of concern. So while Dale has testified that this is a setting that would only be used in very rare circumstances, frankly, we heard the same thing about therapeutic schools for students with IEPs when they were first coming online and in Vermont, and now we have quite a lot of them. So if you create a facility, it has a way of developing its own user base. The other question that hasn't really come up in testimony, and I really want to put on the record, is we have concerns about what problem it is that the state is trying to solve here. So my recollection, and Representative Donahue is really your expert on this, is that when the hospital in Berlin was created, Medicaid, the Medicaid Authority informed Vermont and reminded Vermont that it would be phasing out a waiver that allowed facilities that are termed IMDs. I won't translate that because it's an unpleasant acronym, but it was phasing out a waiver that allowed IMDs, which the Berlin Hospital is one, to have more than 16 beds. So my understanding is that by 2027, the hospital in Berlin will no longer be able to bill Medicaid for those services because it has 25 beds, and the limit that Medicaid will have phased in and imposed then is 16. And I note the math that the state is suggesting that it take 9 beds offline in Berlin and put them under a different category of therapeutic residence, therefore allowing the hospital in Berlin to be a 16-bed facility. So I am not saying that the state doesn't have a right to try to solve that particular problem. We want to be able to bill Medicaid for services that people critically need. But again, building a forensic facility, creating a forensic facility is not the appropriate solution to that problem either. I am aware of my time, and there are other things we could say, but those are the highlights of how the council feels about this. I'm happy to take any questions.
Thank you, Kirsten. And I see that Max has joined us as well. So I think if you don't mind, what I'd like to do is to have Max go ahead and speak, and then knowing that you both have limited time, then we'll take questions for both of you at that time.
That's
That
fine.
work? Okay, thank you. Welcome, Max. Welcome back to House Human Services. Thank you for taking time out of what I know is a very busy day for you and was yesterday. So thank you very much for being here. And the floor is yours to talk about this bill.
Yeah, I hope you can hear me okay.
We can hear you perfectly.
Oh, good. All right. So yes, for those who don't know me, I am Max Barrows. I live in with my parents in Worcester. I have been the outreach director for Green Mountain Self-Advocates for 15 years. I am a person with an intellectual developmental disability. I'm on the autism spectrum, and I get developmental services. So Green Mountain Self-Advocates is a disability justice organization run by and for people with intellectual and developmental disabilities. We started in 1994. And many of our founding members had their freedom taken away and were forced to live for years in Brandon Training School. When they got out of the institution, they got involved in self-advocacy. They knew that just because the institution closed, that the attitudes that built the institution still existed. Today, people with disabilities have rights, but people do not always respect our rights and choices. Our society is set up to make it hard for people with disabilities to use their rights. People with disabilities as a group are treated unfairly because of our disabilities. In other words, ableism is alive and well here in 2023. In response to the many ways ableism impacts our lives, Green Mountain Self-Advocates has peer groups meeting all over Vermont. We support more than 20 local peer support groups with over 600 people with intellectual and developmental disabilities speaking up for ourselves and as individuals and as part of these groups. I'm here to address S89. Green Mountain Self-Advocates does not support the building of a forensic facility for people with intellectual and developmental disabilities. We do not agree with a policy giving Dale the power to say that I am a danger to my community and lock me up. We ask that the administration and legislature explore other options. Green Mountain Self-Advocates believes that when decisions are being made about our lives, we need to be there. Not just one time, but every time. Who knows us better than we know ourselves? We learned that a committee about building a forensic facility has been meeting for a few years. We heard that there were not able to reach an agreement. They were not able to reach an agreement. And correct us if we are wrong, but it is our understanding that people with intellectual and developmental disabilities were not on the committee. Going forward, we ask you to include us, nothing about us without us. One of my advocacy roles, as I'm a member of the State Program Standing Committee for Developmental Disability Service Division. And in fact, in November of 2022, I completed a 2-year role serving as co-chair of this committee. And the plan to build a forensic facility has not been discussed with our committee. S89 is a significant change in the developmental service system of care plan and a drastic departure from how people have been served over the past 30 years. It is not appropriate that the State Program Standing Committee has not been actively involved in this decision. It feels like as if the bill is being fast-tracked. We are thankful to Representative Teresa Wood for bringing S89 to our attention. Many self-advocates are here asking why you're doing this now. Because of the pandemic and the workforce crisis, many of us have been getting through by with reduced services or not having any developmental services. Some reports by agencies say upwards of 40% of services have or still are not being provided. So now when people are not getting the help they need to deal with challenging situations, now is when you want to spend money to build a forensic facility. It seems unfair to put policies in place that could force us to live in an institution when we have not had adequate support to prevent problems from occurring. Last legislative session, and again this year, the Vermont House Human Services Committee has been taking testimony about quality assurance issues with developmental services. And there have been reports in the news about people with developmental disabilities being abused by their support staff. We need to be investing and improving the quality of developmental services, not creating segregated facilities. One way that ableism impacts our lives is often people with intellectual and developmental disabilities are held to a higher standard than those without disabilities. When we make mistakes, it often leads to harsher consequences. Because many of us experience difficulty communicating, sometimes acting out is the only way we have of communicating on the quality of our lives. We understand that our communities need to be safe. We definitely understand the needs for safety, since people with intellectual and developmental disabilities experience abuse at higher rates than other groups of people. But if someone is having a hard time and they are not getting the help they need and they act out, we do not want one of the options on the table to be to lock people up. It's been 30 years since we've closed Brandon Training School. We should be celebrating that we have made progress and recognizing that we still have work to do to fully include people with disabilities in every aspect of society. This means put our energy into investing fully inclusive programs, not going back to programs that segregate. Why go back to those days? My final comments are to remind us of the promise made by Governor Howard Dean when Brandon Training School closed in 1993. Governor Dean said, "I am proud to maintain the commitment of the state to the very kind of services that we still owe to the population that was once at Brandon and is now in the community. We will continue to assure that individuals receive supports and services. We will continue to assure that those services meet acceptable levels of quality. We will continue to assure that persons receiving the services are free from abuse and neglect or mistreatment, to assure that the folks taking care of the people needing these services have etiquette, training, and supports. So our commitment does not end with the closing of this institution. Our commitment continues. All set. Thanks, and thank you so much, for listening to me today.
Thank you, Max, and thank you, Kirsten. I do want to note for committee members that under the name of David Ballou, the State Program Standing Committee for Developmental Services has sent us a letter in opposition to this bill as well. And I do just want to appreciate that we are off schedule and trying to accommodate people who have other things going on that they need to attend to. So it's my apologies to the department in terms of organizing. I didn't connect that the Voices and Choices conference was happening at the same time as we were scheduling this, so my apologies. Barb, we're going to move to you next, if you will, and then we will have the department. Is that Commissioner White? Is that fit with your schedule?
Yes, that would be okay.
Okay, thank you. Barb, we'll just do a brief introduction because I think this is your first time in committee with us, at least this year. So I think it's helpful for you to know who all's in the room since it's not easy to see. So Teresa Wood here from Waterbury, also serving Bolton, Field Score, and Huntington.
Hi, I'm Jessica Brumstead, and I serve Shelburne and St. George.
Hi, I'm Roy Garofano, and I serve Essex and Essex Junction.
Good morning, Representative Dane Whitman from Bennington.
Hi, Noah Hyman from South Burlington and Melissa.
Good morning, Kelly Kayala. I represent Beverly, Andover, Weston, and Winhall.
Hi, I'm Shalene McGill, and I represent Bridport, Middlebury, New Haven, and Weybridge.
James Gregoire, Fairfield, Fletcher, Bakersfield.
Good morning, I'm Dan Noyes. I represent Woolkit, Hyde Park, Johnson, and Belvedere.
Ann Donahue, Northfield, and Berlin.
We'll go around the outside of the room.
Rebecca Silvernagle from Dale.
Calista Smith, Office of Wood City Council.
Julie Tesler from Huntington Partners.
Hi, I'm Shayla Livingston, from the Agency of Human Services, and Monica White, Commissioner of Dale, just stepped out briefly. She's also here.
And good morning, Stuart Scher, General Counsel at Dale.
Lori.
And then Lori, of course, the committee assistant.
Thank you. Thank you, Barb, for being here. And the floor is yours. Please introduce yourself for the record and provide us your comments on S89.
Hi, can you guys hear me okay?
We can hear you, yes. And just before you speak, also, if you have anything in writing, all three of you, if you are able to submit that, that would be great.
I believe that Rachel Seelig, Director of the Disability Law Project, already submitted our written comments. And so I think that you already have that, but if not, Lori can let me know afterwards and I'll forward it. I know that she sent them to you, Teresa, but
okay, I will find them.
Okay, that's okay. I can find them too.
All right.
My name's Barb Prine. I'm a staff attorney at the Disability Law Project of Vermont Legal Aid. I've been here a really long time, like more than 25 years. And I have been representing people who have been committed on Act 248 for years. And I want to say first that we oppose the formation of a forensic facility. We don't think that it's necessary, appropriate, and is not the least restrictive environment for serving people with disabilities. Secondly, we're concerned about the changes proposed in Act 248. We don't believe that those are ready to be at committee. We've had, at a minimum, we need some time to talk to the department about some of the changes because it's flown by so quickly that we think there are things that are missing. For example, Representative Donahue talked about the fact that the standard for initial commitment isn't there. I don't know why, but it was section 17, which is the standard for commitment, is stricken. That doesn't make any sense. That's got to be there. Anyway, we oppose the forensic facility and the changes to Act 248. Right now, I've represented people on Act 248 for years. Many people who are willing to accept their ongoing commitment because they feel it's appropriate for them. Some of whom oppose their ongoing commitment. And I've represented many people in contested hearings, and over my 25 years, I have only won 2 cases against the department because it's very hard to get off Act 248. The standards are very difficult to meet. And yet the department is trying to make the standards even easier to meet, to keep people from getting off commitment and to keep people in facilities. To say that someone who just makes threats can stay committed will make a lot of people stay committed, because a lot of people express anger. Probably a lot of people that folks know express anger by saying, I'm gonna get you, I'm gonna hit you, I'm gonna kill you, without any real thing behind it besides that is my feeling right now. But that can justify an ongoing commitment. We're also really concerned about that someone has to cooperate with treatment. Treatment isn't always available, and treatment isn't always appropriate for people with intellectual disabilities. It's often very hard to find appropriate treatment for people with intellectual disabilities. And sometimes the best treatment is a good place to live with people who care about you, who are keeping eyes on you. And earlier I heard someone say, what's happening now? What's happening now is there are people who have done some really bad things, who are living in our communities with supports and have been for 30 years because they have people with eyes on and arm's length in certain situations. They're living sometimes in very isolated places. Some people are living in places with a yard that is fenced and locked, so that folks can't run away. I mean, there are some people have restrictive lives that keep them and others safe. And that has, for the most part, been working. And it seems to me that part of what's happening right now is the workforce crisis has made it harder for the state to do what they've been doing for years. Stuart and the commissioner know of difficult stories, but there's always been difficult stories of people with problems who've been served in the least restrictive environment, which is in our community. And I think this is coming from a place now of the staffing crisis. And instead of resolving the staffing crisis, it's shuttling people over. I also agree with the statement that if they build it, they will come. Of the 25 people who are committed under Act 248 right now, probably 20 of them, 15 of them can meet the standard for the forensic facility right now, but they've been being served in the community. So I'm also concerned about having the state's attorney and the victim notified before discharge. That, these proceedings should be confidential. People's treatment should be confidential. Having another problem is having this in the criminal arena keeps it from being confidential. But our communities get scared in ways that reflect all our biases when people hear disability and danger, and the reaction of someone who's on probation for some crimes and the reaction of hearing someone with disability and dangerous in our community is very different reactions, because we have fears about people with disabilities, fears that are unfounded, not different than anything else. But this really boils into it. I'm also concerned about the amount of power that the community safety panel has. I think that it's very hard to say, once someone's been labeled with dangerousness, people get very nervous about saying that they're ever safe again. And I think that the community safety panel is really going to have a hard time saying it's okay for someone to get off. It's hard for judges to do. Like I said, I represent people. I'm not usually successful. my clients aren't usually successful. Often that's because they still have dangerous behaviors, but often it's also because judges get nervous about releasing someone from Act 248. So I agree with the statements before that Kirsten Murphy asked, like, what is the problem that we're trying to solve? Why is 2023 different than it's been for the last 25 years? So I urge this committee to not create the forensic facility. I urge this committee to not make the changes to Act 248, and at a very minimum, to give us a year to work with Dale to see if we could come to some agreement on the Act 248 changes. I think, Dale and the Disability Law Project just might need some more time to talk some of this through. Some things like removing the standard for initial commitment, perhaps that was just a mistake. We haven't had a chance to talk all that through. I didn't quite even realize that till today because when Katie was walking us through it.
Okay, thank you. Thank you, Barb. Appreciate your testimony. So just going to open it up for questions from the committee now for just please let me know if your question is directed to a particular witness. Are there any questions from the committee? Yeah, go ahead, Representative Brumsted.
Thank you very much for your testimony. It seems to me very clear, so it doesn't leave with us probably with a lot of questions. I guess I'm just curious, is there ever examples where developmentally disabled end up in prison or in a correctional facility because we don't have a forensic facility?
I think Stuart might be able to answer that question differently. People can be in prison while they're waiting a determination of whether or not they're competent to stand trial. And then once that passes, then a program's developed. It has not been my experience that people stay imprisoned when the opportunity for Act 248 commitment can happen. I mean, some people are found competent with intellectual disabilities. A lot of people with intellectual disabilities are found competent to stand trial, and go to prison. So this is only traditionally, this has been used for people who've been found incompetent.
This is
Ms. Murphy?
Yes.
Yeah, and I would just add, I believe the department will talk about a particular individual that will be moving out of the correction setting. And I'm not at all saying that it's desirable to have people in corrections, but I do want to remind the committee, the Americans with Disabilities Act still adheres in correctional settings. And individuals who unfortunately find themselves in those settings are still entitled to protections and accommodations and do not necessarily need to, could, for example, not being with the general population or, adjustments can be made for their safety and well-being and should be in the very unfortunate circumstance when somebody with an intellectual disability is in a correctional facility.
Thank you. You answered one of my questions about that. So, Representative Donahue has a question, and I see Mr. Barrows had to leave, and I know Kristen is going to have to leave shortly. So, thank you. If you disappear off the screen, we know why.
Okay, thank you.
Go ahead, Ann.
Thank you, Madam Chair. There's a section of the bill that basically says any forensic facility, in other words, now or in the future, that's operated by Dale, DMH or Dale, but it could be Dale, would be excluded from review by the Green Mountain Care Board. Do you have any thoughts about that?
Honestly, I didn't even realize that until today, Representative Donahue. I'd have to think that through. I don't know I mean, our healthcare financing system is a mess. I don't know why that's would be pulled out. It's also interesting because the talk of the facility right now is a certain number of beds within an existing facility. So I don't even begin to know why that would be included, but I don't know what the impetus is for that.
Thank you. Other questions for Ms. Pratt? Yes, go ahead, Representative.
Thank you, Madam Chair. I guess my question would be, first of all, I really appreciate you saying the fact about, or in your assessment that of the 25 people currently served under Act 248, the criteria as outlined, 15 to 20 people, individuals could fit the criteria. So I think that just opens up a lot of questions about that criteria. I do just want to ask though, is there any kind of level of violent or criminal activity that would not be appropriate for community, being served in the community, and would a forensic facility be preferable to correctional facility? Is there any benefit in your mind?
Well, I mean, so you're asking me a tough question in part because I have represented pretty dangerous people. You know, I have represented people who have committed arson. I have represented people who have committed serious assault. I have represented people who have committed sexual assaults and have harmed children. And all those people have been served successfully in the community. I also want to say Act 248 is all, I have one client I've represented many times. He's like, if I was on probation, if I had gone to jail and been on probation, I would be done by now. How come I'm not still done? There is a part of Act 248 that is more restrictive because people can stay committed longer than criminal sentences go. But you know, I think part of it is we have to think about what makes people better. And the strength of Act 248, which we haven't spent any time talking about, is that it's the curative power of relationships. Like some designated agencies do a phenomenal job. Many designated agencies do a phenomenal job with someone who, and you know, you've heard the saying, people who have harmed people harm people. Like people who have been harmed, some of them become people who harm others. And the curative power of relationships is the thing that has allowed me to see people really transform. I've only represented 2 people successfully who've been discharged. I've seen a whole bunch of people get discharged, not a whole bunch, I don't know, 7, because they've completed programming and the department agrees. But I've seen people make real changes over years. People who, you know, I go to see them, they're scary, they threaten to kill me when I show up. And over the course of years, they become people who have trusting, caring relationships with the people who help them and serve them. And one guy got discharged. It was like just such, the 9-year arc was amazing. So part of it is I don't believe that forensic facilities are going to make people better. They're like hospitals. It's like living in a hospital for 9 months. How much better are you going to get living in a hospital for 9 months? So that's part of it.
Thank you. And then we have one final question from Representative Donahue.
Thank you. Yes, you mentioned these are people who have committed serious crimes. But because they weren't competent, they never went to trial. At the initial commitment, what is the standard of evidence or demonstration that they did actually commit the crime they're accused of?
I think that is part of what is perhaps accidentally stricken, but it has to be the evidence of the crime is great.
In current statute.
I believe that's it. I mean, just to be clear, Representative Donahue, in the initial commitment, it happens with the state's attorney and the public defender. They often call me for advice. It's almost always an agreement. I can't remember any initial commitment that wasn't at that point an agreement, but I don't always see them that early on. We represent in the annual reviews.
Thank you, Barb, for being here today. Appreciate your testimony, and we're going to now switch gears and move on to the department's testimony with regard to this. And feel free to stay and listen on. Appreciate your presence here today, Barb.
Thank you so much.
Welcome, Commissioner White, and my apologies for the delay. Things don't always go as planned. So thank you for being here today. And you've been here before, so we'll dispense with introductions, and the floor is yours. And we welcome you to submit your written testimony as well.
Will do. Thank you so much. So for the record, Monica White, Commissioner of the Department of Disabilities, Aging, and Independent Living, also known as DAIL. In the interest of time, recognizing running a bit over, I'll really do my best to be crisp and speak to the very high-level points related to S89. So S89, as you know, will establish a forensic facility in Vermont, and the genesis for why this proposal is being brought forth at this time is that starting in 2021, the legislature asked DMH and DAIL to study a series of issues concerning a gap in the systems. So how do we best provide treatment and assure public safety for that very small number of Vermonters charged with the most serious of crimes who are experiencing mental health or substance use issues or have intellectual disabilities? And so for a period of 18 months, that work group, comprising a multitude of stakeholders, including the Developmental Disabilities Council, studied the issue, but were unable to reach consensus on a path forward to address the issue. So S89 is a result of the administration taking the feedback generated by the forensic study group and putting forward the best possible proposal given that input. So forensic facility is a secure setting in which people involved with the criminal justice system can receive therapeutic treatment. And you've heard where it would be located in Berlin, 9 beds within the existing Vermont Psychiatric Care Hospital building operated by Department of Mental Health. And I would like to emphasize that the selection of that location was not as a result of the issues associated with IMD, but looking to an option that would be the most practical, cost-effective, and existing location rather than taking beds offline and having them gather dust and cobwebs. So it would be licensed as its own facility, a therapeutic community residence in accordance with rules adopted and enforced by DAIL's Survey and Certification Unit. And rarely it could be used for persons under Act 248 supervision. So when a person with an intellectual disability, and that's very specifically intellectual disability, not developmental disability without intellectual disability, so that is a very specific criteria under Act 248. So when a person with an intellectual disability commits a crime and is found by the criminal court not competent to stand trial, the court may commit the person to the custody of the DAIL Commissioner under an Act 248 order, but only after conducting a hearing at which the individual has legal representation and finding all of the following: that the person presents a danger of harm to others, such as alleged to have inflicted or attempted to inflict serious bodily injury to another, or is alleged to have committed sexual assault or lewd or lascivious conduct with a child, and that appropriate custody, care, and habilitation can be provided by the DAIL Commissioner in a designated program. There are presently 27 Vermonters under Act 248 supervision. That number does vary. People are committed. People are discharged from Act 248 on a regular basis. And it is very true that the vast majority of individuals served under an Act 248 order are served successfully in the community. The majority of those folks reside in staff living, and the majority of those individuals are served successfully. So I do want to underscore that. Very specifically that of those 27, one person in that caseload presently would meet the standard for the forensic facility setting. I want to say that very unequivocally, clearly. We heard from a previous witness that 15 people might. That would not be the case. We currently leverage and would continue to leverage evidence-based risk assessment tools and not based just on a threat that might be issued, but really a clinically solid, appropriate determination for that. So of the 27, like I said, the vast majority are served successfully in the community. There are, however, rare occurrences when a person under Act 248 cannot be safely served in the community. If that individual meets a hospital level of care, they can be served in a secure inpatient mental health facility. If they do not meet this hospital level of care and require clinical stabilization for co-occurring conditions in a secure setting, we do not presently have that level of care, which is needed for them to be successfully supported in the community. So the lack of a forensic facility setting has, on rare occasion, resulted in repeated elopements, the commission of additional crimes causing harm to others, and the rearrest, charge, and detention of those individuals in a correctional facility. A few individuals have repeatedly assaulted and caused injury to their staff. Those actions have made those staff unwilling to continue to serve these individuals and have presented challenges in identifying new staff interested in taking on that work. So as a result, due to the unavailability of staff willing to care for or work with these violent individuals, again, very rare, but very real, who require 24/7, either 2-on-1 or 3-on-1 staffing, the state has been left with no option but to engage contract staff, many of whom lack the expertise of staff within our system of care, within the designated and specialized service agency system, to best serve the needs of those most challenging, the individuals who present the most challenging behaviors. And finally, and this is what keeps me up at night, and I'm going to try to not cry, because this is very much a very real risk to the person themselves under Act 248 supervision of being harmed by a community member who is reacting to an assault by the person under Act 248 or a perceived assault. We've heard in the news recently of people showing up on the wrong doorstep and what has happened in those rare circumstances. It keeps me up at night, and I'm trying to not get emotional. And there was a box of tissues here. Where did it go? That one of our folks under supervision is going to get hurt themselves in that way. And so we would much rather serve people in a therapeutic facility than in a correctional setting. And we would much rather the people not get hurt, either the person under Act 248 supervision and the community. Right now, as I've mentioned, there is a person who had been committed under Act 248 who was recently arrested for new violent crimes. And this person is in a correctional facility because we do not have this therapeutic setting that is secure in which they could have been stabilized. So in conclusion, the forensic facility contemplated under S89 will be an important resource for the rare occasion when a person cannot be safely served in the community. if it becomes law, there will be multiple safeguards and levels of due process to ensure that Vermonters who require that level of care are served in the community when it is safe to do so. Very, very clear on that point. This is not intended to, oh, this person has challenging behaviors, we're going to throw them in there and lock and throw away the key. Absolutely not intended to be a period of stabilization in the tune of months, so that they can be safely and successfully supported in the community setting. We, Dale, are required under federal law, such as the Americans with Disabilities Act and the Olmstead decision, as well as under Vermont law, to serve individuals in the least restrictive setting. And we do want all Vermonters, including those under Act 248 supervision, to be part of their communities. This forensic facility would be an additional option to ensure that all Vermonters are able to be served in a setting appropriate to meet their needs and which protects them and the community at large. So that's the high level of what I would like to convey today. So thank you. I'm happy to answer questions. I also have Stuart Schur, our general counsel, in case you ask any legal questions that I need to phone a friend on.
Okay. Thank you, Commissioner White. Appreciate you being here today and your team here today. So are there questions from the committee, Representative Donahue?
You haven't asked me.
Oh, I didn't see. That's okay. I'm sorry.
You can go back. It's fine. I have several questions.
Okay.
Thank you, Commissioner, for being here and your testimony. First question is, what role does the expanded Vermont Crisis Intervention Network crisis play in all of this?
Thank you, Representative. That's a great question. The VCIN, as Vermont Crisis Intervention Network is known, is a very important part of our continuum of crisis care for Vermonters with intellectual or developmental disabilities who are experiencing a crisis in their period. And that is not correlated with Act 248. It is primarily, we have a number of beds around the state available for persons with in a crisis, and it is not, however, a secure setting such as a forensic facility would be, and equipped to assure that level of security and safety in the event that a situation like I described. So is that helpful?
Yes, it is. And then I wondered, I think you explained this, but it sounded from the previous witnesses that there wasn't any stakeholder input in this, this proposal, but it sounded like there was a working group that couldn't reach consensus. So it just seems strange to me that there's the proposal doesn't actually reflect what stakeholders in a formal way wanted included or not included.
Right. And so yes, reiterating that there was the forensic working group that did meet for, I think it was a year and a half, but were unable to formulate the consensus on what Vermont's path forward should be on the forensic facility issue. And so I would defer to the Agency of Human Services for specifics beyond the Dale scope of what is or isn't included in S89 versus the input from the forensic facility group, other than it was completed and it was considered as part of this work.
Can I?
Sure. I think that there's maybe a follow-up to that question that you just asked.
Okay.
So I'll wait till you're done though.
And then I wondered if you considered on the panel, you considered adding Office of Racial Equity and the Trauma and Resilience Director. It seems like that would be apropos for the situation.
Good question. I don't know if those two specific bodies have been considered, but we'll certainly take that back and consider it. Thank you.
Thank you. I just would like to follow up to one of the questions that Representative Garofano had on the working group so I am part of the Joint Justice Oversight Committee, so Mr. Shore had presented at that committee, and then there was a follow-up, members, you can find a follow-up report that was submitted to our committee as well as others on that, I think, that's in the legislative reports. So it was actually my understanding, and please correct me if I'm wrong about this, but that part of that working group was about whether to expand Act 248 to include people with traumatic brain injury and people with dementia. That seemed to be what the report out to Joint Justice Oversight at least addressed, that there was no mention of people with intellectual disabilities during that report out. And I'm just, my recollection of the report, having recently read it, was that essentially the department said they didn't have the resources in order to be able to expand Act 248 to those other groups. Is that your understanding in terms of what part of that group was supposed to be considering at least?
I do believe that, yes, that was part of the task of that particular group, although, and here's my phone a friend option to Stuart, who was the Dale representative there.
Yes, so good morning again, Stuart Scher, General Counsel of Dale. Representative Wood, it was in fact part of the recommendation was to note that there were limited resources to expand the population that would be subject to an Act 240 commitment order, because currently it's only applicable to those with intellectual disabilities, not a whole broad range of people with developmental disabilities or dementia or traumatic brain injuries. So, but that was not the purpose of the working group, and the ultimate report was to also indicate what the current resources are and the current system and framework for getting individuals to Act 241. So I think it was broader than just saying that we don't have the resources to expand, but also to acknowledge that there's an Act 248 process for intellectual disabilities.
Did it, I don't recall the report mentioning anything about a recommendation for individuals with intellectual disabilities being included in a forensic facility.
I don't recall that. I would have to defer to the report itself. I haven't read it in a while.
If I could, Madam Chair, I also recall one other thing that I wanted to say, that I guess in response to testimony this morning that I heard and I echoed and I do want to underscore is the importance to me personally, to our department, to the state as a whole, and all of you, is the importance of combating the fear and the prejudices, and that persons with intellectual disability are more likely to be a victim than a perpetrator. And that does not go away with the addition of this forensic facility as an option. The need for us all to continue to combat some of the fear and prejudices and stereotypes and ableism and that sort of thing. Like that is and will remain a fundamental tenet of what we do. And, you know, in terms of part of my work in this role when situations come up, people will not be considered for admission to this facility based on community fear and the torch and pitchforks of that can happen, and you know, continuing to combat that is absolutely a priority. I just wanted to underscore that because I don't want to make it sound like that doesn't happen, because it does. So, thank you.
Representative Donahue.
But I want to follow to the chairs and then a couple of my own. The committee, the stakeholder, whatever, the work committee, did that include under either the statute that set it up or active involvement, any members of the DD Council or members of the standing committee under Dale, or anyone with lived experience of a developmental or intellectual disability?
I would have to look at the statute that that came out of to confirm what the required composition was for participation. I do know that I believe it was Susan Aronoff of the DD Council participated in that group, whether it was as an official designated member of that committee. I don't recall that offhand.
So a couple others. First of all, I know you referenced a couple of times that would be very rare. These are rare situations. Does Dale have data that it can share with us, say past 10 years, how many times this would have been a likely or necessary component of the system of care?
We can do our best to do a look back on what data that we do have, in our records for Act 248. I don't know that we can necessarily, we can do our best to provide that. It's just challenging to pull like which data points. We'll do our best to provide that. But I can say that in the little over 2 years that I've been in the role of Dale Commissioner, there have been two circumstances where it would have been appropriate to have the period of stabilization in the forensic facility. One in the past, one presently.
So second question was what I had asked earlier. In terms of the standards for an initial commitment, which appear not to be in the new draft, but I'm just wondering about current statute. What are the standards in terms of any of levels of evidence or threshold of findings of evidence that the person actually committed the crime they were accused of that led them to being reviewed for Act 148?
Thank you, and I will phone a friend again.
So thank you, Representative Donahue. First, I would want to say that the language that you're looking for is actually in Title 13 of Vermont statutes. It's in 4823. And what it does is it makes clear that the initial commitment may be ordered exclusively by the criminal division. So the criminal division, not the family division, which is solely responsible for conducting judicial reviews annually, has the authority to place the individual into custody if the evidence is great, as Barb indicated. That standard has never been in statute, so it's not as if it was struck from.
Okay, that was my question.
Right.
Is it in statute anywhere that the evidence of the crime is great?
I don't practice criminal law at this point, so I don't know if that standard is in statute. What I can do is that it's never been in this section of the statute.
No, I understand.
Right, and so what the court looks at is have the criteria that are set forth in Title 18, Section 8839 been met? And that means, does the person have an intellectual disability? Do they present a danger of harm to others? And does the commissioner have a designated program that can meet the needs of the individual? So are they a person in need of care, custody, and rehabilitation?
So if that's the criteria, it doesn't include a relationship to the allegations of the crime. It's just that
if the crime was if there's evidence of the crime, and again the criminal division makes that determination. So perhaps the court, that a judge from the criminal division could speak to what standard they use. I just can't answer that question. I don't know the answer to that question.
I think we all know they did it.
Yeah.
I think that's the standard in statute.
If it has been charged, if there's evidence of whatever that degree is, and then they've been deemed incompetent, then the court then conducts the analysis of the three-pronged test to decide whether they present the danger of harm.
Okay.
So sorry,
Yeah.
I see Ms. Prine has her hand up and she's consulting the green books.
Somehow they're still easier than online, us older people. So Representative Donahue, what Stuart says is correct. There's in 13 VSA, the court has to find that the person is a person in need of custody, care, and habilitation. And the definition of someone who needs custody and care, habilitation is over in Title 18, which is the judicial proceedings, and that means that they have to have been found that they present a danger of harm to others, which means, and that's under 18 VSA 8839(1). And that means the person has inflicted or attempted to inflict serious bodily injury to another, or has committed an act that would be a sexual assault or lewd and lascivious with a child. So a judge has to find that that the person has done those things.
But there's no standard, well, I don't want to get into a long discussion of that.
In case law, the standard is clear and convincing evidence. That's what the case law, it's not said in here.
It's not in statute. Okay, thanks.
Clear and convincing is not in statute, but the person has inflicted or has attempted to inflict these things is in statute.
Thank you, Ms. Pride. You have another question?
Well, yeah, I guess I do. One other question is that there was reference to the this is a period of months. It's wouldn't be long term. And I'm familiar with both populations, but of course, in a person is not competent to stand trial, for instance, for a mental illness. That is a fluctuating status. So the fact that one can get better from mental illness and then become able to stand trial or to be perhaps perceived less dangerous despite the severity of an earlier crime can happen more, right. Whereas a person with a developmental or intellectual disability is much less likely to suddenly improve in their status and be competent to stand trial or improve in their overall. So I'm just wondering about that relationship of it only being a few months projected versus it being significantly longer for a person with a developmental disability than with a mental illness in terms of potentially being committed to a forensic facility.
Thank you, Rep. Donahue, for the opportunity to clarify on that front. So to be clear, the testimony that I have given is largely specific to the folks with intellectual disabilities under Act 248.
The question is just the length of time.
Right. Right. And so in terms of the length of time, so it would not be tied to a competency restoration process for persons with intellectual disabilities. So in other words, the intent of their time and stay at the forensic facility would be to be stabilized clinically stabilized as appropriate. And concurrently with that our community partners are able to further strengthen the community-based programming based on the individual's need to assure that upon discharge that the person is safely and stably able to be served in the community setting. So that is intended to be temporary in duration, as short term as possible, to assure that level of stabilization in that clinical and secure setting, to be able to do that. And again, we want to serve people in the least restrictive setting. We're required to serve people in that least restrictive setting and to move it expeditiously as possible so that can occur.
Thank you. Representative McGill.
This may be a bit redundant, but we've been hearing a lot about how, these folks are already being served and have been for years within our communities. So with that in mind and thinking about most effective use of state resources, a commitment to the least restrictive environment, and the fact that there's currently only one person who would really meet the criteria, I'm just wondering what work has been done with community providers to try and develop the capacity to treat that kind of higher need within these individuals' communities.
Great question. And so the 9 beds would and could be utilized both by persons under Department of Mental Health supervision, as well as and primarily for folks under coming in through the criminal system on the DMH I don't want to say side of the house, but the side of the house, for lack of a more graceful term. And it would be available in the event that a person with an intellectual disability would need to leverage that sort of setting. So, in terms of resources, it makes sense to have that for, because many of the times, and I don't know, I think I did say co-occurring conditions, but being able to leverage the clinical expertise of mental health clinicians in that setting will be really important in that secure setting, because in these situations, as it pertains to Act 248, the co-occurring conditions can include any number of mental health conditions, and being able to safely and securely serve that person in that setting is the thinking behind that. Does that get what you were getting at, or did I completely?
I'm just wondering if there's room to use in our currently existing kind of areas of treatment, if there's ways we can be doing this in existing structures rather than building kind of a whole new system of.
And the answer to that is no. We don't presently have the option to have that secure setting for that level of care. If someone meets the inpatient hospital level of care, we're good. But if they can be safely and successfully served in a community setting, we're good. It's kind of that gap that we don't have presently.
Thank you. I just want to follow up on Representative McGill's question, because I had a question that was similar to that. Has the department looked at other contractors, so outside of the designated or specialized service agency? Have you looked at other sort of community-based providers that may or may not be, currently located in the state, that might be able to provide this kind of service if for some reason there's a determination that the DAs are not able to do it?
So if I could ask a clarifying question, are you talking about a different entity coming in to provide community-based services?
Yes, I am.
No, but I will preface that with when in the instance of these extraordinarily challenging circumstances, these very, very few, we have looked nationally for individual specific resources for the people. Because one thing I don't know if I said was that each of these Act 240 persons served under Act 248, the programming is individually tailored based on their specific needs. And for those situations where our designated agency partners have in some cases reached out to us for can we pull in other resources, and there hasn't been an adequate solution in these, again, very, very rare circumstances to be able to serve someone.
I guess. I'm, to be honest with you, I'm not clear about your answer. At first you said no, and then you said maybe you did. I'm not really sure.
Okay, so I apologize for the lack of clarity. So at a global level, pulling in another vendor to come in to in addition to the designated agency system, the answer to that is no. That has not been contemplated. However, on individual basis for an individual being served where their designated agency itself may be having extraordinary challenges in meeting that need, we have looked to, is there an out-of-state sort of solution that might be helpful for that individual person?
All right, thank you. Yes, that's clarifying. Thank you. Okay, and I think Representative Dunn, you had a question, and I don't know if anybody else has any questions, but we are going to wrap up here in the next couple of minutes.
Thank you. Yeah, I just wanted to refer back to another question I asked earlier. Is there a rationale that Dale would be asking for an exemption for any future forensic facility that it would be operating from the current requirements that the Green Mountain Care Board give a certificate of need?
Phone a friend, please.
I would say that an exception to the certificate of need requirement is one if there's a state purpose. And so the argument here is that the purpose for which Dale would operate the facility would be for that purpose and would not have to go through the extensive
So that's not,
process.
it's not a healthcare facility, in other words, is what you're, healthcare facilities would go through a certificate of need process.
That's right.
And this is not being designed as a healthcare facility.
I believe that it's, I would have to look at more carefully at the Green Mountain Care Board CON rules, but
That would be helpful.
I would be happy to do that. I'm just trying to answer it here.
I understand, yeah.
That'd be helpful to get the follow-up, yeah.
Yeah, certainly.
And I know that therapeutic community residences are not required to go through the certificate of need process. And so this, although I know it's kind of slightly off, so that may be the connection. So, but thank you, Mr. Schur, for following up with that. I appreciate that. Representative Noyes, did you have one, Representative Whitman? Okay, lots of questions, I'm sorry.
So you said there's 20 individuals that are currently in custody and one is incarcerated and.
27 presently
27.
under Act 248 supervision.
Could you explain like where are they living now of the 27? Like what does their housing look like? What is their, where, obviously don't need the exact that, but where in the state are they all in a, like one area? Are they spread out or just?
Sure. Yes, happy to provide that general overview. So the vast majority of the folks are in staffed living situations. So in a home living with 24/7 staffing patterns, and often 2-on-1, not exclusively. In terms of where they're located, just like everyone else in Vermont, all over the place, which is great. I mean, that's again, that's the intent. And that's what we want to foster is the custody care and habilitation, and being able to serve the person in the community, supporting their interests, supporting their therapies as appropriate, and working on behavioral, some of the behavioral therapies and often offender-specific therapies, and working successfully to do that. So to prevent reoffense and ideally, if and when possible, to be discharged from Act 248 supervision because they have gained the skills to be able to regulate the behaviors that had brought them to the point of committing the crime that got them under Act 248 supervision. So again, by and large, that is how the system is set up to work, and that is by and large how it is working. And but for those rare couple of circumstances where we are not adequately serving people in the community because they're co-occurring conditions, and the acuity has risen to a level that our community partners, as well, as fantastic as they are, they don't have that ability to serve someone in that secure, clinical, secure setting for that situation. Rarely, but.
Representative Whitman, and then I'm going to get the final question.
I had 4 questions, narrow it down to 2.
Okay, that's okay.
This just came up earlier, and so I wanted to just ask for the record, what role do you envision medication administered against an individual's will have for individuals with a disability in a forensic facility?
So that could be, if clinically indicated, that could be an option which doesn't currently exist in the community setting.
Thank you. And second, you mentioned individuals with substance use disorder were also contemplated to be for a forensic facility. Now I was just wondering, do you see those individuals as more under the jurisdiction of the Department of Mental Health or Dale?
So as insofar as substance use goes, so for Dale's scope related to this, it would be persons committed under to Act 248 supervision only. However, some of those folks are also experiencing the co-occurring mental health challenges as well as substance use in some cases. So again, this setting will have the ability to treat the whole person based on what their needs are.
Only if they're under Act 248.
As it relates to my purview and area of expertise would be if they have the Act 248.
Thank you.
And the final question that I have, Commissioner White, is the role of the panel. It appears, at least the way this is written, that the panel, so that the commissioner, the Dale commissioner, has the ability to recommend continued placement, either in this designated facility or in another designated program that might be a community-based program, and is relying upon, not relying upon, but taking into consideration also the I don't know if it's a decision or if it's a review or what it is by the panel that the commissioner also sits on. So it seems a little odd to me that the panel is making a recommendation to somebody who is sitting on the panel. That whole construct, could you speak a little bit to that construct? Because the same actually would be true for the Commissioner of Mental Health, but we won't talk about that here because I'm only dealing with Dale. But it just seems odd that the panel on which your position sits would then be making a recommendation to your position.
Right. So thank you for that question. And without looking at how the language is worded specifically on that front, I think so. I might tag in Stuart for the legal part, but the existence of the panel is intended with to have the expertise of the Department of Disabilities, Aging and Independent Living, Department of Mental Health, Department of Corrections, and I believe it's DCF. And that too, presently, it's gone through a couple of iterations, but on the respective systems of care, and but ultimately, I, as commissioner, or my successor as commissioner, is the one who is responsible for the person under Act 248 supervision. So I think that my understanding is that the intent of those processes is to work together to assure collaboration and alignment between all of the respective systems of care. However, I will tag in Stuart if I am missing anything from a process perspective on that.
Yeah, I would say that the members of the panel would be the Secretary of Human Services, Commissioners of Mental Health, Dale, and Corrections. And currently, the commissioner has to make a determination as to one of the three prongs that the criminal court considers at the time of initial commitment, and then the family division considers in determining whether custody should continue, does the commissioner have a designated program? This facility would constitute a designated program, so it makes sense for the commissioner to weigh in on whether he or she believes that the placement in the forensic facility is appropriate and can meet the needs of the individual and the department. So I understand your question as to the apparent inherent conflict in having a commissioner make a recommendation or being a member of a panel that makes a recommendation to the commissioner. But that ultimate determination is made by a commissioner. And again, it's a recommendation. It's a recommendation to the court, whether it's the criminal court or the family court. And that court can actually reject that outright. So it's an internal decision that's made at the Agency of Human Services, and then it's presented to the court to decide whether to accept or reject it.
And so I guess you just referenced, Stuart, that's an internal decision. I get that, and I get that the commissioner people who are committed to the custody of the commissioner makes a recommendation back to the court about whether that should continue or not, or I get that. I'm not really sure I agree with you about, the construct. But the other thing that I noticed that seems to be missing, and perhaps operationalizing would be different, but there's no clinical expertise on the panel with regard to, disability status, mental health. I'll just keep it to disability status. And so what would be the intent about clinical expertise?
Sure. So great question. Thank you for that. So the intent absolutely is that decisions of the panelists will be informed by clinical evaluation. And so insofar as Act 248 goes, we presently leverage a number of evidence-based risk assessment tools as part of our usual annual review for potential discharge process. And so that would continue leveraging those evidence-based risk assessment tools, as well as leveraging, we have recently entered into a contract with Dartmouth Hitchcock Medical Center for psychiatric medical consultation for persons with intellectual and developmental disabilities. We would be leveraging that as a resource. There are also similar, although I won't speak to with specifics, but similar clinical resources on the Department of Mental Health side that will serve to inform the perspective of the respective commissioners of the departments. So it would not be us, kind of making decisions or recommendations based on, what we think we know. It would be fully informed by clinical best practice and clinicians at the table.
This wraps up our testimony on this for this morning, and I want to thank all the witnesses and particularly the current witness for being here and your team, as well as Ms. Prime, who still is on. Just for committee's perspective, our intent is to make recommendations to the Judiciary Committee, which has possession of this bill. So we will have further discussion about this and development of a memo of sorts, I guess, to the Judiciary Committee in relatively short order. And I'm not exactly sure, to be honest with you, how that's going to fit into our schedule. So stay tuned for that. Do we have witnesses in the waiting room? Yes. Okay. So if you wouldn't mind letting them in, Lori. So you could have probably figured out we're not taking an official break. But I am going to ask the witnesses if we could pause for just like 2 minutes to do what we need to do. That would be great. Thank you, folks, for being here. We have, as you have already figured out, run over slightly on our testimony, and so members have not had a chance to do what they need to do, if you get my drift. So we're just taking a 2 minute break in order to allow members to do what they need to do. And we'll be right back. And thank you very much for your